and welcome to this wonderful program on Budget 2025. So, welcome to all the members who have joined in, the panelists, and of course, our esteemed speaker for today, CA Chaitanya sir. Sir, a very warm welcome for the session. 2 days back, Madam Nirmala Sitharaman announced a stellar budget where although all the limelight have been shifted on the rationalization of tax rates for individuals, we also have a lot of other amendments, although relatively it might look like a very smaller finance act. But having said that, we also have some amendments in other aspects of the Income Tax Act where it might look more trivial, but it has a lot of far-reaching impact. So in order to analyze each of these amendments, and in order to get some expert insights from esteemed speakers across, we have organized this particular budget session for 4 days, starting from today through Thursday. Very a warm welcome for all the participants who have joined in for this wonderful program. Before starting today's session, a quick introduction about Chaitanya sir. Sir is holding a postgraduate degree in commerce from Sri Venkateswara University from Tirupati. He's also a qualified chartered accountant, qualified in the year 2005. He also has qualified the Information Systems Audit course from ICAI, also securing third rank all over India. He has completed the certification course on international taxation offered by ICAI. He has also completed bachelor's degree in law in 2020. Besides this, sir is currently pursuing master's degree in international taxation from Nalsar University, Hyderabad. Professionally, Sir started his practice in 2005. He has varied experience in statutory audits, internal audits, and tax audits. Clientele include various listed and unlisted companies, banks, insurance companies, trusts, firms, and other entities. He has represented clients before various income tax authorities and has also been actively involved in the preparation and presentation of appeals before the Honorable Commissioner of Income Tax Appeals and Income Tax Appellate Tribunal, Hyderabad. He has written articles on direct taxation for Chartered Accountants Study Circle CASC Chennai and International Fiscal Association IFA Chennai chapter. Sir specializes in direct taxes and also has keen interest in international taxation. Apart from this, he also hails from a family of chartered accountants. Sir, it's an honor to have you on this. I hereby formally forward the proceedings to you. You may please proceed with the session.
Thank you.
Participants may please note that if any questions, please post it in the Q&A box. Chat box also can be used for any other discussion. Thank you.
At the outset, I would like to thank Karnataka State Chartered Accountants Association for giving me this opportunity. I would like to express my heartfelt gratitude to the Direct Tax Committee of the Karnataka State Chartered Accountants Association for asking me to present my views on the topic relating to charitable trusts, and my deep regards to Deepak sir, who is unable to join today. Initially, when I was asked to speak on the amendments relating to charitable trusts, I was actually surprised because today my agenda has got just 3 amendments. Most of the amendments relating to charitable trust had come in last year itself. So I don't know why, but this time the number of amendments are low, but still Deepak sir wanted me to give me his views. So I said, sir, considering the number of amendments will take little time and we'll try to close the session in half an hour's time. So within this time frame, I thought I'll present my views on each of the amendment that has come. In fact, all the amendments that have come as far as the charitable trusts are concerned have been beneficial amendments. There have been no amendments which are harsh on the assessee. But I sincerely believe that there is still scope for a lot of benefit to be bestowed upon the charitable trust, considering the fact that they do a lot of service to the society. The problems associated with the trust forever has been that, especially after the new regime, has been that the trust cannot perform the activities on their own. They'll have to rely upon a chartered accountant or their authorized representative to do these tasks. And any mistake on the part of the chartered accountant would obviously disentail the trust for its benefits. Therefore, the provisions relating to charitable trust have been very, very harsh in the last 3 or 4 years. But this year, they have made some amendments. They have relaxed some of the timelines, but there is still scope for bettering the provisions. I hope the new tax bill would take that also into consideration, but nevertheless, we will try and understand what are the amendments that have come in this time, and we will deal with those intricacies involved in those amendments. First, we'll deal with the amendments relating to section 12AB. 12AB has got two amendments this time. The first one deals with the validity of the certificate issued by the Commissioner of Income Tax. We all know that as far as the registration is concerned, as far as the new registration is concerned, there are various cases, there are various scenarios envisaged in section 12A. 12A subsection 1 clause AC envisages 7 different kinds of scenarios, and each of the scenario, it asks us to get the trust registered, and there is a particular form that is verified. That is a form which is provided for filing the application. We all know that there was an erstwhile regime called as 12A or 12AA. There was a registration that was possible under that regime. On 1st of April 2021, all the charitable trusts moved to the new regime, which is registration under section 12AB. Once they wanted to move into the new regime, the Act prescribed that they will have to file a form and state that they have already been registered. Automatically, registration would be granted for 5 years. That aside, in all other cases, that is where a firm has to get itself registered by converting its provisional to regular, or if it has already got a regular registration, renewal of that registration, or where its registration has become inoperative due to operation of 1046 or 1046A, to get its registration operative under 12A, or for the if there is a modification of the objects, if there are new objects which are getting incorporated, or there are some objects which are getting removed, for modification of the objects, the registration has to be obtained again by filing the form. For all these activities, there is a specific form which has been prescribed. So where the registration has been automatic, that means where you are applying for a provisional registration without commencing your activities, or for conversion of the old regime 12A, 12AA to 12AB, only in these two cases, there has been a form prescribed which is called as Form 10A, we all know. And in those cases, the registration is through the computer automated route. You will get your registration within 3-4 days. But in all other cases, the CIT will call for a hearing. The CIT will verify whether your objects are charitable, whether your activities are genuine, whether you are complying with all the laws which are applicable to the charitable trust, and then only he will move forward for granting of registration. So, except for those two odd cases, in all other cases, the registration was subject to verification by the principal commissioner of that particular jurisdiction. And when the principal commissioner grants you the registration in a order, in the order that is prescribed, in fact, the order is Form 10AB. The order has to be given in Form 10AB. That form, wherever the commissioner is issuing, the erstwhile section stated that the validity of that form or validity of that registration was only for a period of 5 years. So the erstwhile registration time had a limit of 5 years. That has now been amended as far as section 12AB is concerned. They now state that where you have made an application under clause 1 to clause 5 and the total income of the charitable trust is below 5 crores, then the commissioner shall grant the registration for a period of 10 years. So what was the power of the commissioner erstwhile was to grant the registration for a period of 5 years. That has now been extended for a period of 10 years. So it is the commissioner who has now the power to decide whether to give the registration for 5 years or to give the registration for 10 years. But that is not a choice of the commissioner. He will have to see whether the two conditions mentioned in the proposed amendment have been complied with or not. The first condition is whether an application has been made in clause 1 to clause 5 of the erstwhile 12A subsection 1 clause AC. If you can see here in my presentation, I have written the applicable section. So when you're undertaking one particular activity, you will have to see under which subclause your application is being made. And accordingly, for those clauses, the time limit has now been extended to 5 years, subject to compliance of the second condition. The second condition states that where the total income of the trust does not exceed 5 crore rupees, only for past 2 years, prior to making the application, in the past 2 years, if the total income of the trust is below 5 crores, then alone the commissioner is entitled to give the registration for a period of 10 years. Now, what was the logic behind this amendment? What was the intention of the legislature while giving this amendment, proposed amendment, has been explained in a memorandum to the finance bill. The finance bill memorandum states that the intention is to reduce the compliance burden for smaller charitable trusts. So they don't want the smaller charitable trust to come to the CIT once in 5 years. So they want the smaller charitable trust. That means trust whose total income does not exceed 5 crore rupees. They want them to come to the commissioner once in 10 years. So they would be coming only once in 10 years, and therefore the registration, the verification process would be happening only once in 10 years, and therefore the renewal would also happen once in 10 years. Now, if I were to plug in the conditions that are prescribed into the old form, the current scenario would look something like this. This is the law after the amendment. If the amendment is passed, then the law would look something like this, where you are under an old regime. I don't think, although the proposed amendment says that it is from subclause 1 to subclause 5, I sincerely believe that there is no possibility of subclause 5 coming in, because this is long over. So in case where there is a possibility, in case where the trust is going for a renewal of registration, or where it is going from provisional to regular, in all those cases, what was the total income of the trust in the two years prior to the year in which the application is made, that has to be verified. And if it is below 5 crores or equal to 5 crores, the commissioner now has to grant the registration for a period of 10 years. But if it is below 5, if the total income is above 5 crore rupees, then the registration cannot be for a period of 10 years. It has to necessarily be for a period of 5 years. And the CIT has the power only to grant the registration for a period of 5 years. So once in 5 years, the trust will has to go up to the CIT and get the registration renewed. The problem here is that the total income of the years which are being tested for that 5 crore limit will only be the last 2 years prior to the year in which the application is made. So even in the initial 3 years, if you are below 5 crores, in the last 2 years prior to the year in which the application is made, if the total income is exceeding 5 crores, then yes, the registration granted will be only for a period of 5 years. So these are really intended for trusts which are very small in nature and where the total income is below 5 crore rupees. Now, but the limit of 10 crores is only for the purpose of the first 5 clauses mentioned in section 12A. That is where you are converting from an older registration to the new registration, or where you are getting your renewal done, or if you are moving from provisional to regular registration, or if there is a modification of the objects, or if you are trying to convert your registration from inoperative to operative, all those cases this 10 years or 5 years limit would apply. But where you are applying for a registration for the first time, if your activities have not started, commissioner can only give you the provisional registration for 3 years. If your activities have commenced, commissioner can only give you the registration for 5 years. As far as the new registration is concerned, the commissioner has got no power to extend it for a period of 10 years. It is only for a renewal of registration, or where there is an existing trust which is trying to get itself registered for any of the conditions mentioned in subclause 1 to 5. Only in those cases this 10 years is permissible. In the case of new registration, the commissioner has got no power. He has to stick on to the old limits of 3 years and 5 years accordingly. So as far as the new registration is concerned, there is no change. Only for the existing trust, this 5 years or 10 years limit would be applicable. That too, the trust cannot decide whether it is applicable for 5 years or 10 years. It is the commissioner who, while passing the order, will see whether the total income has been exceeding the 5 crore limit or not, and accordingly he will decide whether to give 5 years or 10 years of the registration. Now, we'll take a very small example here to demonstrate what is the law that will happen after the finance bill gets finance bill becomes the Finance Act 2025. For example, you have a charitable trust. It has got the new registration. So when it has got the new registration, generally for an old trust, I am sure you would have seen in your form 10AC, the registration is valid for 5 years. That is from assessment year 22-23 to assessment year 26-27. Generally, for all the existing trusts which had the old registration under 12A or 12AA, since the new provisions have come into force from 1/4/2021, until assessment year 21-22, they had the old registration under 12A or 12AA. The new registration under 12AB was given from assessment year 22-23 to 26-27, which was a period of 5 years. Now, if you want to renew this registration, the section states that you will have to apply for the renewal at least 6 months prior to the expiry of that registration. So if your registration is valid till assessment year 26-27, it means that your registration is due for renewal on 1/4/2026. Therefore, you will have to apply for renewal on or before 30th of September 2025. So if you have made an application on or before 30th September 2025, then in that case, the commissioner will examine whether for the last 2 years, that is for financial year 22-23 and for financial year 23-24, or financial year 23-24 and for financial year 24-25. So 24 March and 25 March, he will examine whether the total income of the trust is below 5 crores or above 5 crores. If it is for below 5 crores, then he will grant you the registration for the next 10 years. If it is above 5 crores, the commissioner would only grant you the registration for 5 years. So this is how the renewal and the fresh certificate would be granted by the CIT in accordance with the proposed amendment. I hope this example has tried to convey what is the proposed legislation. Now, the challenges that have come forward as far as this amendment is concerned is that what do you mean by total income? Total income for an educational institution or a hospital would be completely different from the total income that is applicable to a religious trust. Both would be having a registration under 12A. Nevertheless, the total income computation could be far more different. What do you mean by total income computation? Generally, the same language has been used even in deciding the applicability of the audit report, whether to go for 10B or to go for 10BB. The same language has been used, which is the total income without considering the provisions of section 11 and 12. So what do you mean by total income? The moment you say total income without considering the provisions of section 11 and 12, it would mean you will have to take into account the total income of the trust, and from that income, you will have to reduce the expenses which are incurred for earning that income, and thereafter compute the net income. That net income would be called as your total income. So in the case of a charitable trust, the total income is not equivalent to the total income of any other institution. It is different from type of the educational institution. For example, take the case of a hospital or an educational institution. The fees or the receipts of the hospital could be earned only if there is a corresponding expenditure. In those cases, it is only the net profit or the net income which has been incurred by that educational income, which can be called as the total income. But if you go to a religious trust where there are considerable amount of donations received, there is no expenditure incurred to earn the donation. In those cases, it is only the gross income which is taken for the purpose of total income. So therefore, what is total income would now form a considerable aspect of litigation as far as this section is concerned. By far, Income Tax Act has been, at least the CPC and the other institutions have been trying to say that for the purpose of section 11 and 12, total income would mean the total receipts of the trust. In my personal view, I am unable to concur with that view, because total income is a word that is already defined in the act. And in the absence of a specific definition under 11 or 12 or any of those sections, total income could only mean that which is mentioned in the section. And therefore, I would personally go with the view that not the total receipts of the trust, but the total receipts minus expenditure incurred to earn those receipts would be constituted as the total income. I am sure, I would believe that this total income was erstwhile computed fantastically under section 56 and 57. But unfortunately, after the introduction of 1310 into the act, where they now decide that if the trust loses exemption for some reason, like if the audit report is not filed or if the return of income is not filed, if there is a violation of the proviso to 215, in all those cases, there could be a possibility of losing the exemption, and therefore 1310 could come into picture. 1310 has been introduced to reduce the problems created by 56, by provisions of 56, because erstwhile when the when 1310 was absent, then the total income of the trust was computed under the head income from other sources. But after introduction of 1310, the difficulty posed under 56 has now been reduced due to the introduction of 1310. But that doesn't mean that the word total income changes its definition. I would still believe that total income would mean the total receipts of the trust minus the expenditure that has been incurred for the purpose of earning that income. I am sure there cannot be any expenditure. Even if there is an expenditure, it would be only very little for the purpose of taking in incomes like rent or interest or donation. All those incomes do not require considerable amount of expenditure. But if you look at institutions like educational institutions or hospitals, predominant amount of fees that is received or the receipts of the trust could be only because of incurring the expenditure. Therefore, I would believe that the total income has to be computed individually for each trust depending upon the facts of the circumstances of that case. Unfortunately, there is no guidance given as far as what is meant by total income. If the legislature wanted to give a definition, I am sure they would have given. But this word total income can pose considerable amount of challenge, especially presently. There are a number of notices which are being issued to say that you have filed the audit report in 10B while the applicable audit report was 10BB, or you have filed the audit report in 10BB while the applicable audit report was 10B. So considering that litigation, this total income word could provide some amount of ambiguity. I'm sure probably the law would clarify in the due course. The second problem in this amendment is that, yeah, 12A and 80G were there existing in the act, and both of them required renewal once in 5 years. While for smaller trust, 12A renewal has now been reduced. The time limit has been reduced and extension has been granted up to 10 years. There is no similar language appearing in 80G. 80G continues to be once in 5 years. So what is the point in giving 12A, which is once in 10 years, if you have to go for the purpose of 80G once in 5 years? Therefore, I think a parallel amendment in 80G would have been beneficial, but unfortunately, there is no such amendment coming in 80G. So only for the purpose of 12A, the time limit for, the validity of that extension, validity of that registration has been extended, but no such amendment has come in 80G. Probably the association can represent and allow the amendment to be made to the finance bill. That could be one possibility that can be done. This is with regard to the validity of the registration granted by the commissioner. When we go to the second amendment, they have made a amendment with regard to specified violation. Specified violation is the list of conditions provided in the act, where if any violation is observed in the list that is given here, that would automatically lead to cancellation of registration. So there is a difference between the specified violation in the present legislature and the erstwhile conditions for cancellation in the previous act. Earlier, there was a possibility of not pursuing the cancellation because of the existence of a reasonable cause. Now there is no condition of reasonable cause. If any of the conditions of specified violation is found to be carried out by the charitable trust. If there is a specified violation, if there is a recording of a fact that there is a specified violation, then it would automatically lead to of registration, and there is no possibility of claiming any reasonable cause as far as any of the specified violations is concerned. Now, in this specified violation clause, the last amendment had come by way of Finance Act 2023, where they said if an application is not complete or if it contains false or incorrect information, then it would be called as a specified violation and therefore would lead to cancellation of the registration of that trust. The present amendment, proposed amendment, whatever is proposed by the Finance Bill 2025, it says we will only pursue cases where there is a false or incorrect information. We will not pursue cases where the application is not complete, because the application has always been extensive. It has been very, very lengthy. If you look at Form 10AB, it says, give me the square feet of the building, it give me the survey number of the land, give me the details of the immovable property. The application has always been very, very lengthy. It has been comprehensive. It has been trying to collect all kinds of information, because tomorrow if they want to attach the assets of the trust, they wanted to have complete picture. Therefore, they have tried to collect as much as possible in the application. But for some conditions, if the application is not complete, then there was a possibility that the registration of the trust could be cancelled by invoking this provision. Application not getting completed is a very, very trivial cause unless there is a malified intention attached to it. So on that basis, they have tried to omit this particular sentence, which says now the conditions for specified violation is that application contains false or incorrect information. The memorandum, which explains the reason for the amendment, states that minor default should be kept out of the specified violation definition, because that should not lead to cancellation of the registration of the trust. Therefore, on that basis, they have tried to remove what is not complete here, and therefore they have tried to ensure that the amendment covers only cases where there is a malified intention or there is a willful default in trying to provide or suppress the information in the application. So except for those cases, minor defaults of incomplete application would not lead to cancellation of the registration of the trust. These are the two amendments which have come in as far as section 12AB is concerned. We'll now move on to section 13, which talks about the provisions relating to related parties as far as a charitable trust is concerned. We all know the conditions of related parties. There have been extensively defined in section 13.3. Section 13.3 states that the related party definition given therein is only for the purpose of section 13.1c. So if there is a benefit that has been given by the trust to any of the related parties, then to that extent there would be a violation, and therefore income could get taxed under the specified income defined under section 115 BBI. Added to that, there is a equivalent penalty also mentioned in section 271 AAF also. So under these provisions, what is a related party forms the crux of the issue. Till last year, the law was that any person who has given a substantial contribution would be treated as a related party. What is meant by substantial contribution has been defined as the contribution by a person from the inception of the trust till date. If it exceeds 50,000 rupees, then that person was called as a related party. For example, if the trust was incorporated in 1947 and up to 2025, that means a whole lot of, say, 78 years, if a person has contributed more than 50,000 rupees, then he would be called as a related party, even though he may not be related to any of the author or the management committee. Therefore, the amount of substantial contribution defined earlier of 50,000 rupees was much, much lower, and the manner of computation was very, very difficult. It said in 1 year or from the inception of the trust till date, the cumulative amount, if it exceeds 50,000 rupees, that person was called as a related party. Unfortunately, the law was very, very difficult to comply on this particular aspect, even for chartered accountants, because they had to certify this information in the Form 10AB. There was a circular which was reducing the impact, but nevertheless, the law is now amended. The law now says that in 1 year, if a person contributes 1 lakh rupees, or from the inception of the trust, if a person has contributed an amount exceeding 10 lakh rupees, then yes, he is called as a related party. So only in those circumstances that person would be called as a related party. In all other cases, if the cumulative contribution is below 10 lakh rupees, then he would not be called as related party. If the contribution of that person is less than 1 lakh, then he would not be called as related party. But if the contribution of a person is more than 1 lakh in 1 year, and the cumulative contribution is less than 10 lakhs, then he would be regarded as a related party only for that 1 year. And for the next year, he will become an unrelated party. Similarly, the erstwhile provision also stated that the relative of such donors or the concerns in which such donor has substantial interest are all treated as related parties. In the present definition, they have tried to remove the relative of such donors, the substantial contribution donors, relatives of such substantial contribution donors, and the concerns in which such substantial donors have significant substantial interest have now been removed. It is only the donor, if he has contributed 1 lakh or more in a year, or if he has contributed 10 lakhs cumulatively till the financial year end. In those cases alone, such donor alone would be regarded as a related party. His relatives or his concerns would not qualify as related parties as far as section 13(3) is concerned. And I am sure 13(3) would have relevance with regard to 13(1). So these are the amendments which have come as far as the charitable trusts are concerned. I am sure I had been able to convey all that I intended to convey. I would be happy to take any of your doubts. I thank once again the association for giving me this opportunity.
Thank you so much, sir. I hope the participants have been benefited with the insights that you have shared and the knowledge that you have shared, not only on the amendments, but also on the general registration processes and the relative questions. Thank you so much for this wonderful session. Also, thanks to all the participants for joining. Please join for the upcoming sessions as well. You may please use the same link that was shared today for joining the next session. Thank you so much. Thank you so much, sir. We'll end the session here.
Yeah.